Sam Seder, Emma Vigeland on the Majority Report. Want to welcome to the program, or welcome back to the program, Professor Randall Eliason, a white-collar crime professor at GW Law School and author of the Sidebars newsletter. We'll put a link to that, obviously, in our podcast and YouTube description. Professor, welcome to the program.
Thank you. Glad to be here.
So the jury starts deliberating today. I've read what you thought the defense's closing arguments should be. And they centered around basically two what you perceived as fundamental flaws in the prosecution's arguments. The first being that the prosecution hadn't necessarily proved that that Donald Trump knew that the payments to Cohen were actually not for legal expenses. And the second being that it wasn't, he wasn't necessarily, if you assume that he was actually knew that he was lying about that he wasn't lying about what he perceived to be a crime. Did I articulate that right? And if so, could you just walk us through that and elaborate and then compare that to what they actually argued?
Yeah, basically, I mean, I think fundamental flaws in terms of the defense argument, not necessarily that I would agree that they're fundamental flaws, but I think the defense's strongest argument was based on a lack of proof of intent, a reasonable doubt defense about whether the government had actually shown that Trump himself knew these records were false and caused them to be made with an intent to defraud and to commit another crime. Because I think the defense could have put on a much more effective case if they had simply said, look, you can assume the hush money happened. You can assume sex with Stormy Daniels happened. You can assume we paid Cohen back and it was all reimbursement. Mr. Trump disagrees with all that, but you can assume all that's true. But the government, the charges here are that Mr. Trump himself caused these false documents to be made, knowing they were false, and did it with an intent to cover up another crime. And that's where the evidence has fallen short. I think that was the defense's strongest case, because then it really comes down to Michael Cohen's credibility. And they spent a lot of time hammering on that, of course, which was understandable. But if they had been willing to take all the other stuff out of the case and just really hone in on, look, there's really reasonable doubt here. Is it really false to say, if I'm paying back my lawyer, that that's a legal expense? You know, when I put that in my bookkeeping, is that really criminally false? Does it really matter if there was a retainer or not? I mean, he was on the staff as an attorney. What difference does it make whether we call it a retainer? And was there really evidence that Trump himself focused on details like how is this being entered in the ledgers of the Trump organization? He's got accountants. He's got people that do stuff like that for him. So you can accept the hush money scheme and that it was sleazy and inappropriate, maybe violated some other laws, but he's not charged with those laws. You know, Cohen pleaded guilty to it. But in terms of these actual charges, the defense their best argument was that the proof fell short of showing that Trump himself knew about the false records. So that was my argument about what their best defense would be. But as I also kind of predicted in that piece, they didn't do that, because the actual defense was kind of pure Trump. So everybody else is lying. They're all out to get me. I'm a victim. And I've got to send my lawyers in to destroy Michael Cohen and Stormy Daniels, and spend a lot of time, you know, even though the defense said in their openings, Stormy Daniels' testimony doesn't really matter, which is right. I mean, it doesn't really matter whether the sex happened or not. So they said she didn't really matter. Then they kept her on the stand for hours in an ineffective cross-examination that only highlighted the kind of salacious details of the relationship. So I think, you know, whether it was because their client made them, or whether it was, you know, their own tactical choice, I think the defense would have had a much better shot with a really sharply focused, reasonable doubt argument, putting aside all the other hush money allegations and things like that. And they didn't really do that, and they didn't really do it in closing.
And just getting back to their best case that they could have presented, that first element about the retainer question. But why would Michael Cohen even perceive it as something for him to do as an attorney to pay off hush money to someone if he's not directed to do it? I mean, do attorneys, I imagine when he gets hired, right, as a retained lawyer, as a counsel, of counsel, Trump's not going like, and also incidentally, you obviously handle any type of lawsuits we get and this and that. And also you pay off all of my paramours, but make sure you do that 10 years after the fact. Like that to me seems like a weird instruct. I mean, if you're going to put an attorney on a retainer, I can understand that, but it's like, there would have had to have been some type of notion that the attorney knew this was in his purview.
And they also paid him more than what his basically fees would have been, right? And essentially to get to pay him back for paying taxes on those payments as well, which also highlighted the unusuality of the situation.
Well, that I can understand it. Like if I hire an attorney to like incorporate me and they front the money, I'd pay him back. But I've asked him to incorporate me. How does Michael Cohen come up with the idea that this is the person I'm going to pay off?
No, the whole fronting money thing is, as you noted, I mean, extremely unusual. It's not really what lawyers do. I mean, his best argument would be it was a contract. It was a legal contract at the time, putting aside whether it's possible campaign violation. And so he was, helping his client by advancing the money to pay the contract, expecting to get reimbursed, but it's certainly not typical and not something that you do pursuant to a retainer. But that's kind of my point. I mean, the defense argument that, this really was a retainer, these were legitimate legal expenses, we weren't really reimbursing Cohen for the hush money payment, just wasn't credible. It was not credible at all, especially when Trump himself is on the record saying it was a reimbursement. He tweeted about it in 2018 that they had reimbursed Cohen for these payments. And his own lawyer said it in one of the E. Jean Carroll lawsuits, I think it was, where they characterized them as reimbursements. So it wasn't credible to try to argue these were for legitimate legal expenses. What I think would have had a better shot is to say, okay, yeah, it was to pay him back for this and other expenses. So we called our payments to him to reimburse him a legal expense.
Okay,
is that really
the idea is, so the idea
it was a legal
just
expense. It was a payment to my lawyer, right? Yeah.
So
and then the retainer.
The how you named it in the ledger is really just like, how else would you refer to it?
Yeah, and what difference does it make whether there was a retainer or not? I mean, again, they've got to prove intent to defraud. It's not just a technicality that this maybe wasn't technically true. I mean, we're talking about a felony here, or a crime. They've got to prove intent to defraud. Who's defrauded by whether you call it a retainer in your own internal documents that no one else has a right to see? I mean, that kind of argument, I think, would have given them a much better shot of convincing at least one or two jurors to say, there's a reasonable doubt here about, I mean, the whole thing was slimy and sleazy, and we don't like it, but did Trump actually commit these particular crimes? Maybe not.
Well, I think it's also the problem of the fact that the federal charges on fraud were not pursued earlier, right? I mean, this is basically working backwards from a mistake that was made previously, because I think they could have made a much broader case about Trump's criminality as a fraudster, as someone who cooks the books internally, and then also like to banks and to the government, if the civil fraud cases were within the scope of a criminal case. But that's not how things shook out. I mean, maybe you can go over that history a little bit, Professor, but like this piece of fraudulent behavior, or alleged fraudulent behavior, I think could have been a much stronger case, obviously, if it was presented in tandem with the other fraudulent activity.
Yeah, I mean, it's always hard to tell from outside of a criminal investigation all the reasons that went into those decisions, because we usually only know a pretty small percentage of the relevant information, because most of it is secret grand jury. So there were certainly a lot of suggestions floating around of a broader possible criminal fraud case, that would have included Trump himself. I know one of the counter arguments to that was there was no actual dollar loss in these frauds. And so for criminal purposes, often that's not a good criminal case. I mean, they brought the civil fraud case, but there was really not much evidence that the victims lost any money. The banks all got repaid and things like that. So factors like that enter into it. Would have been similar issues about proving Trump's personal knowledge, again, in a criminal case versus that of his attorneys and things like that. But it's hard to say from the outside why they backed away from the larger fraud case. It certainly did look like it had some potential appeal as a larger criminal case, like you said.
So, what are the possible outcomes that we could? I mean, who knows how long the jury's going to deliberate? I mean, theoretically, right? They could be they come out with a verdict this afternoon. But what are the potential outcomes?
Yeah, I would, like you said, it's impossible to say. It'd be really unlikely to come back today, I think. I would expect with this number of charges and kind of the gravity of the case overall, you'd expect them to take a couple of days, at least. But so possible outcomes are finding of guilty on all 34 counts, an acquittal on all 34 counts, a split, guilty on some counts, not guilty on others, or a hung jury where they're hopelessly deadlocked and they can't reach a verdict on any of the counts. Or conviction on some counts and hung jury on other counts. I mean, there's a lot of possible variations with 34 counts in play here.
And so, just to be remind people, the jury has to be unanimous on conviction of on any particular count. So you could theoretically have the jury unanimous on one count, and then hung jury, I guess, on 33, or acquitted on 33.
Yeah, it's possible. It doesn't seem all that likely in this case, given the facts. Since all the charges are so similar and the documents are so similar, it kind of feels like it'll be all or nothing.
If it's a hung jury, obviously, if he's acquitted, that's probably the end of the story for this case. If he is, if there's a hung jury, then what happens? Bragg makes a determination whether to bring this case again, but I mean, that seems, well, you tell me. It also seems unlikely that he would do this again.
No, the hung jury gives the DA the right to try the case again, and then, like you said, that's a decision that they make, kind of evaluating all the information they have about how they thought the case went. Was it a hung jury 11-1 for conviction, or was it 11-1 for acquittal? The factors like that. But pretty common to try again. Usually if you think your case was righteous in the beginning, that you thought it was appropriate to bring it at all, then you will try at least one more time if there's a hung jury to prove
Presumably
it again.
That would not resolve itself before the election, though. I
assume not. It could potentially. It'd be up to the judge and the DA how fast they wanted to reschedule it. It's certainly not impossible for it to happen again before November, but I guess I don't know really enough about New York practice to know how likely that is.
Hey, folks, don't forget to hit the subscribe button and check out our daily show. We do it every day at 12 p.m. Eastern for about 2.5 hours. We even take phone calls. You should check that out.